may be seated. We're back in session. We don't usually do introductions again, but since we have a lot of new players in the audience and a new player up here, we're going to go through that again. We're back in session on a second hearing, Anderson versus Slinger. And I'm Judge John Stark presiding. We have Judge Jared Smith, who's also a member of the 6th DCA. Visiting with us today on this case is the Honorable Michael Cranick. He ordinarily is his day job, circuit judge in the 18th Circuit. I'm sorry, that's okay. Okay. So we're prepared to move forward. If I could have the parties please stand and identify who's with you at council at council station.
Good morning, Your Honor. Stacey Haverfield, I represent the appellants.
Okay.
Christopher Winter of the Winter Law Firm. I represent Cindy Slinger, Nicole Slinger, and David Slinger.
Okay.
And good morning, Your Honor. I represent Troy Waddell, Kim Waddell, David Jacobs, and Lisa Jacobs. They are also named as appellees, although technically we actually agree with the appellant's argument. I will not be presenting any argument today.
Okay. Thank you very much. We remind everybody in the audience with us today to please put your phones and devices onto silent, and we will begin with Ms. Haverfield. You're recognized.
Good morning, Your Honors. May it please the court to introduce myself again. My name is Stacey Haverfield. I represent the appellants in this appeal. They're the plaintiffs in the lower court trust dispute. May I reserve 5 minutes for rebuttal, please?
Got it.
Thank you. We are seeking a complete reversal of the challenged order in this appeal. We are before this court because the trial court improperly dismissed the appellees from the trust dispute and then further denied the appellant's request to add the appellees as nominal defendants to the second amended complaint, the operative complaint. The appellees are alleged to have improperly received and accepted trust property, and as such, they are properly brought within the jurisdiction of the court and are necessary to have the court render a complete and final judgment. The appellants seek the return of that property, and they can't do that without including the nominal defendants. It's important to keep in mind where we are in this process. So we're at the motion to dismiss stage. We haven't gotten that pretty bleeding yet. And at that stage, the trial court has limitations and certain restrictions in what he is able to do and not able to do. Here, we made the argument that the trial court exceeded the 4 corners of the complaint in 2 ways. That alone is reversible error and requires this court to reverse the challenge order in its entirety. We raised 5 issues on appeal. I would like to focus on the first 3, please. Issues 1 and 3, I'd like to point out a unique component. Issue 2, in my opinion, is really dispositive of the case in our favor. Let's start with issue 1. Issue 1 deals with personal jurisdiction. Personal jurisdiction is a defense that needs to be raised at its first opportunity. Here, that wasn't done. There is a split in the districts as to whether or not raising personal jurisdiction can be done in an amended motion.
If we're familiar, you covered that in your brief with the split of the jurisdictions. What do you think we should follow?
I think you should follow what this court has been doing historically, is the text of the rule. The rule does not permit a judicially created exception, which was actually expressly acknowledged by the 4th, the 3rd, and the 5th, all of which permit an amendment to keep the personal jurisdiction defense alive. I think the better, more reasoned course is what the 1st district has done and what the 2nd district has done, which is follow the text of the rule. The text of the rule does not permit a defense to be raised in an amended motion. And it most certainly does not permit a defense of personal jurisdiction to be raised after the hearing on the amended motion in a document called a supplemental document. For that reason, we submit that defense is waived, and it'll be interesting to see how this court falls on that particular issue. The second unique point deals with issue 3. Issue 3 is constructive trust. And what the trial court did in entering its motion to disperse, order dismissing, was it confused, again, the split between the districts. So there's a split between the districts as to whether or not constructive trust is both a remedy and a cause of action, or solely a cause of action. Here, you'll see language in the challenged order that reads both. It's not a cause of action, yet you have to meet these elements. It's only a remedy, yet I'm going to enter a motion to dismiss with prejudice based on that remedy. They're incongruous. They're mutually exclusive concepts. They can't exist together. It'll be interesting to see how this court falls on that particular issue and to address my particular take on that. Again, I side with the second and the first on that one. I think, as Judge Altburn said in Collinson, we can see how confusing it becomes when one tries to view constructive trust as both a cause of action and a legal remedy. According to Collinson, it is better as an equitable remedy. Again, it's an extraordinary remedy, no one's disputing that. But certainly at the motion to dismiss stage, it is inappropriate to dismiss with prejudice nominal defendants based on that remedy. So those are the two unique points that are presented to this court. I'm not aware that this court has weighed in on either one of those, and I'm happy to speak more about it if you so wish. Otherwise, I'd like to turn to what I think is the dispositive issue in this matter, and that is issue 2. So now we're going to get into basic trial 101, and that is when a trial court is viewing a motion to dismiss, it may not weigh the allegations in the complaint. It also may not go beyond what is either in the complaint, the allegations, or the attachments to the complaint. Here, the trial court did both. The trial court exceeded the 4 corners of the Second Amendment complaint, the operative complaint, and for that reason alone, the challenge order should be reversed in its entirety. So how did it do that? Well, we had the allegations in the motion to dismiss. So first let's start at the beginning. The operative complaint contained, I think, 361 paragraphs, allegations, and had 11 counts. The folks we are seeking to add are the appellees. The appellees are nominal defendants. They're nominal defendants and needed in this particular trust dispute because the allegation is they accepted trust property. And my clients, the appellants, seek to have that trust property returned because they improperly received that trust property. So the only way that the court has any authority to direct or request anything from the appellees is to make them nominal defendants. They're nominal defendants. So they're brought in as a technicality. They're necessary, but they bear no fault. They have no responsibility. And finally, they can expect no recovery. But yet they need to be made a part of the lawsuit for a full and final judgment to be rendered in this particular case. So how did the court go beyond the complaint? 1, the court weighed the allegations of the complaint. For example, we have 3 appellees. And the court discusses in its order this NXT account. The NXT account is an account that was jointly held. Exhibit 15 shows that. Exhibit 15 attached to the operative complaint shows that. The appellants also
court see from that it's not titled as a trust asset?
But the court also then overlooked the allegations in the complaint, which were, yes, it was a joint account, but it was a joint account for convenience only. And convenience in this situation is a term of art. There are accounts that are convenience accounts. And those accounts, as we reported in our reply brief, those accounts are accounts that do not belong to the other joint owner. Rather, they belong to the initial owner and are supposed to flow in accordance with the testamentary documents of that
But
original
even if
owner.
it's the other owner, if it's not trust, that's a completely separate entity.
It was supposed to be a trust asset, though, and that is our argument. But even still, we allege very expressly that that was a convenience account. The will of the decedent was attached to the complaint. The will was a pour-over. So in any event, that asset was to flow into the trust. But even still, The allegation is there, and that's all that the appellants were required to do at this stage, again, with the motion to dismiss. So they alleged, yes, there was a joint account, but whoa, it was a convenience account. It did not belong to Nick. It belonged to the decedent. It contained all of her money, and it was supposed to flow into the trust. The trial court, in its order, wrote, the joint account was not trust property and would never have become trust property. That's actually a direct line out of the amended motion to dismiss filed by Megan and Nicole, and that's record 2624, and it's paragraph 17 and 18. Relying on items outside of the allegations and the attachments in the operative complaint is improper. Also, weighing the allegations. So the trial court was trying to assess, okay, I've got this convenience allegation, and then I've got this joint. Well, I'm going to assess that I don't think it would have been. I don't think you can prove that. But that's inappropriate at this stage. At this stage, the trial court is merely to look at the allegations and see if the allegations are adequate, otherwise stated sufficient to state a claim. The trial court did not do that. The trial court, another example, we were trying to bring Cindy in as a nominal defendant. Cindy is the wife of Rick. And the court relies, again, on the amended motion to dismiss, that's paragraph 12, and then arguments of counsel at the time of the hearing that the only reason she's made a party is because the plaintiffs, my client, the appellant, suspect she received money from her husband, who received money from the trust and the LLC. That's inappropriate. We allege that she accepted trust property, and that is sufficient to warrant bringing in nominal defendants so that the court can make a full and final judgment related to those claims that were alleged.
When you say to their argument that the statute says requires a trust distribution as opposed to in possession of the trust property.
One, that in my mind goes beyond reviewing the allegations in the complaint. So
the judge isn't allowed to look at the statutory requirements to see if the premise of their argument for this person being added even exists.
yes, the court can look to make sure that the elements are there, or that there's a well-founded or reasonable basis. But what you're addressing is the personal jurisdiction statute, related to trust property, not the underlying count. So for constructive trust,
So wasn't that incorporated into all of the causes of action? The reference to that statute?
yes, it was.
So then how come the trial court would be unable to review that portion of the statute and looking at the four corners of the complaint and determining whether or not those other persons, as the statute contemplates, were recipients of trust money?
Fair enough. I think the court can read the statute. For purposes of determining whether or not the claims of undue influence, tortious interference with an expectancy, and breach of trust are met, the personal jurisdiction statute doesn't have anything to do with those counts as alleged against, in this case, one person, Nick. Related to personal jurisdiction, and to your point, Judge, the incorporation, certainly the trial court can read the statute, but there was sufficient allegation, even though the word distribution wasn't expressly used. There is an allegation, paragraph 15, these nominal defendants received trust property improperly, and the appellants seek to have that trust property returned. So the fact that the word distribution wasn't used, I think, is of no moment. That's a mixing of words, or the allegation is sufficient, it's adequate. Now, maybe you're thinking, well, how are they going to prove it? But see, that's not the analysis here. This is a motion to dismiss. So the question becomes, were the allegations adequate enough to add the appellees to the second amended complaint based on the allegations?
If you could then allege anyone holding trust property and hail them into this court in the state of Florida, and the trial judge can't apply these principles to determine, is there something that's happened that makes them belong in this action?
Oh, I don't, so I'm sorry if I gave you that impression. I mean, to be clear, the statute is very broad. I mean, the personal jurisdiction statute under the trust code is very expansive. So the likelihood is if there's a sufficient allegation in the second amendment complaint, somebody somewhere is going to have to answer it.
Well, that sounds like you're agreeing with me.
I-
All it takes is a blanket ball allegation that someone in Wyoming is in possession of trust property because someone's accounting for it, I had to go there, and they're then here. Distribution or not, whatever reason you think they're in trust property. Let's say it was a vehicle and it had been sold and it's out there. Is that a distribution? Do they have to prove a distribution? Or they can just bring them in because you're saying they belong here?
At the motion to dismiss stage, I do believe that it is just the bare allegation. And you've noted, I mean, the Southern District case that you're referencing, the Wyoming, I mean, that's what that court decided. The court decided we have to look at the trust. And if the trust is Florida focused, then Florida courts have the authority to hail people into court. And
If
that's
it's a
exactly,
distribution of trust,
please, I'm sorry.
if it's a distribution.
Correct. Well, that statute, only section 8 applies to us, in my opinion. That statute section gives a variety. And unfortunately, there aren't a lot of cases interpreting this particular statute section. So really, the only guidance we have to go on outside of the broad language contained in the statute itself.
But is it wrong? If you're traveling under 2A8 of 736, 0202, and it says accepts a distribution from the trust, and your position is, well, they've received other benefits or side sets or offshoots from the trust, how is that accepting a distribution from the trust, as alleged in the second amendment complaint?
Well, one, I think that goes a little bit beyond just the bare allegation. All that has to be made is a bare allegation or a sufficient allegation. A review of the operative complaint shows that they did that.
But it
Now,
also has to meet the statutory requirement. The judge can look at the statute and they can look at the complaint and apply those alleged facts to the statute. Could they not?
they could, but I think focusing solely on the word accept or focusing solely on the word distribution, it is not appropriate. You're cherry picking a word out of the statute construct as a whole. But the allegation in the second amendment complaint was that the appellees received trust property. So we are suggesting that they inappropriately have trust property that was given to them and it should be a part of the trust.
But the allegation, taking it as true, right? All allegations in the complaint are taken as true. The allegation in paragraph 15 is recipients of various transfers of money belonging to the trust. I mean, just looking at the plain language of that allegation, that's different than accepts a distribution from the trust, right?
No, I will disagree with you, sorry. No, I don't think it needs to be that specific. Again, this is a roadmap. Whether ultimately the appellants are able to prove that these were distributions coming from the trust, that's for a later day.
But don't you have to have both subject matter and personal jurisdiction before you can proceed forward?
Yes,
I mean, you can't have one without the other.
yes. But here, I mean, it's important to keep in mind where we are. I mean, we do have subject matter jurisdiction. We would suggest that we have personal jurisdiction by virtue of the waiver, but even outside of the waiver, we have personal jurisdiction. Again, we think it's been waived. We think we have both of those. But even still, even if we have both personal jurisdiction and subject matter jurisdiction, the focus should be on the complaint itself. And here, the judge exceeded the complaint. The judge weighed allegations, and the judge reviewed arguments at the motion to dismiss hearing and the allegations contained in the amended motions to dismiss. That's wholly inappropriate. And that in and of itself warrants a reversal of the challenge order on appeal, setting aside the other issues that you're talking about. Again, it's important to remember where we are procedurally in the case. The allegations were sufficient. The court did not stick to the four corners of the complaint under those two reasons. And for that alone, the challenge order should be reversed in its entirety.
You're well, your time of judgment reserved.
Yes, please.
Please.
Thank you.
Mr. Winter, you are recognized.
Thank you. I'd like to start where Ms. Hammerfield left off, which has to do with whether or not any cause of action was stated against any of the defendants, the three defendants here in the first place. They did not allege any recognized cause of action. They're trying to get a remedy, constructive trust, without a cause of action, without suing them as a defendant for a recognized cause of action, specifically alleging they did absolutely nothing wrong. They did nothing. They're a nominal defendant. They're not trust beneficiaries. The reason why trust beneficiaries that are nominal defendants have to be joined is so that, we're in an in rem situation, and the reason why 736.0202 is broad with respect to trust beneficiaries, because when you've accepted a distribution from the trust, they say it's a Florida-based trust, and therefore you have jurisdiction over that person to the extent that they receive trust distributions so that they can bring those back. And it's in rem, what are they entitled to for the
What would you say their remedy would have been? Well, an action out of state, or how would they try to bring that?
Well, they could attempt, look, they don't have a recognized cause of action. They didn't allege unjust enrichment, because unjust enrichment.
Is that the only way that you can avail yourself to constructive trust, is only through an unjust enrichment?
You have to have a recognized cause of action against that person. If they've been unjustly enriched, then yes, you may have a cause of action for constructive trust. Constructive trust, one of the requirements under the elements is unjust enrichment. And unjust enrichment under the CFB partnership and Cockle, which is a Supreme Court case, they both say that the money has to come directly from the plaintiffs. Nowhere in this case has the money come directly from the plaintiffs. The plaintiffs aren't even trust beneficiaries unless they win their rescission count on the trust amendment. They're here really as outsiders, but let's assume for the sake of today that they are trust beneficiaries and they have some standing to do something. They don't have standing. They don't have all the property that they allege. They allege that Mick Slinger did something wrong by putting money into an LLC and that money should have been trust property, but it never was trust property. It never went into the trust. They're saying it should have been trust property. And then,
Are your arguments conclusory at this point in time, and you're going outside the four corners?
not going outside the four corners at all with respect to that. They've alleged that property that should be, they've specifically alleged that there was an LLC, the Family Farmer LLC, that Rick and Mick Slinger got portions of. Rick and Mick Slinger also got distributions while the decedent was alive, not when the decedent was dead. And the trust, and then the so-called transfers to Megan and Nicole came out of that joint account. Ms. Haverfield says, well, the judge went beyond that because he concluded that it would never be trust property. But let's assume that's okay. It might be trust property because they did allege this convenience account. But at the time the money was sent, it wasn't trust property. It hadn't become trust property. The transfer wasn't trust property.
Why isn't that more appropriate than summary judgment?
Because they have to allege a cause of action against these particular defendants, and they haven't. All they're saying is, what they said is Mick Slinger got money into the joint account, and then gifts were made to his daughters. That's what they said. And they've attached this up. That was never trust property. It was never distributed from the trust. It was never part of the trust. It had nothing to do with the trust. Cindy Slinger, they made no allegations as to how she purportedly came into contact with trust property. If you read at the hearing, they said, when we were discussing it among counsel, and Mr. Lindy, in his response, agreed, and he used a different example about somebody being a thief. But they had said, well, Rick got the money, Rick got the distribution, and he put it into a tenancy by the entirety's account, so we have to join her. That's really what. But they haven't alleged. They didn't allege that, and they didn't allege that she did anything wrong, or how she came in, that it was a distribution from the trust, or anything else. Claiming that property should be part of the trust doesn't make it trust property. The reason why 736.0202 allows such broad jurisdiction for distributions of trust property, because by accepting that, you've accepted a Florida-based benefit on a distribution as a beneficiary of trust property, and you can be called into court about the trust, not necessarily about personal jurisdiction, but about who's deserving of distributions from the trust. That's what the difference is. With respect, so they've stated no cause of action with respect to any of these three defendants. They haven't alleged that it came from a distribution from the trust, and they haven't alleged unjust enrichment because this isn't the plaintiff's money, and that's one of the key elements in order to get unjust enrichment, in order to get constructive trust, because unjust enrichment is one of the elements of constructive trust. You must allege that the plaintiffs are the ones that confer the benefit. Now, they do have an adequate remedy at law. She didn't discuss that in order to get an equitable remedy, you have to have a lack of an adequate remedy at law. They have a tortious interference against Mick Slinger. They've alleged that Mick Slinger, by doing all these transactions, tortiously interfered with their inheritance. And they stated a cause of action. It survived the motion to dismiss. So they have an adequate remedy at law. They don't have a remedy against these particular defendants. Now, as to the waiver of the person,
How do you distinguish the Holmes by Holmes versus Holmes case? It's a mouthful. I don't see anywhere in that case where there was a constructive trust that appears to be imposed out of the air. No accompanying cause of action that you're asserting must exist here. All that we see in this case is that they asserted constructive trust. So how would you distinguish that case?
I'm not familiar. I don't have a recollection of the Holmes versus Holmes.
So it's 463 Southern Second 578 First District Court of Appeal case. And I mean, it's a life insurance case. It's much similar decided by the Browning versus Browning case.
Oh, that's the life insurance. Is that the life insurance
Well,
case?
they're both life insurance cases.
Right.
And in Browning versus Browning, you can see that they do mention an unjust enrichment action, but they don't. It doesn't seem in any way, shape, or form that they rely upon it. In the Holmes case, there is no unjust enrichment action. It's purely constructive trust.
Right. Those life insurance cases appear to be some sort of an exception with respect to the benefit coming from the plaintiffs, because I think both of those life insurance cases have to do with spouses and have to do with they should have been a beneficiary, should have been named, and the person changed the beneficiary at that time. So generally, there's a claim against the person for not having the beneficiary, but they've also gone against the person who is the apparent innocent wrongdoer. But that has never been outside of any of those life insurance cases. This isn't a life insurance type case. This also isn't a case where there was any I mean, we're talking, in my view, apples versus oranges when you're talking about the unjust enrichment for the constructive trust and who should be the beneficiary of the proceeds of a life insurance policy under a contract. But that's the only basis that I can think of to distinguish them.
They both, just for the record, they both rely on Florida Supreme. Well, these Holmes have relied on the Florida Supreme Court case of Washington versus Edwards, and I don't know that Washington hasn't been mentioned with unjust enrichment action either.
Yeah.
They all appear to be situations involving an innocent party that has funds that allegedly are not supposed to be parties' funds. So, well, thank you, Counsel.
Yeah.
Could you respond to opposing counsel who were talking about the 736.02.288, what your client's position is when it comes to the distributions of the trust in the court's order? How was that addressed in the order?
It was addressed. All the judge said about the long-arm statute is they didn't meet the requirements of the long-arm statute.
But he uses the word long-arm jurisdiction.
Pardon?
He uses the word long-arm jurisdiction,
Correct.
which seemingly goes to a Venetian salami issue, not under the trust statute.
That's correct.
And that issue wasn't, personal jurisdiction wasn't raised until after the hearing on the motion to dismiss, correct?
It was not raised until after the hearing on the motion to dismiss. We filed a supplemental brief on that.
So why should that even be relied upon when arguably that flies in the face of what the rule says?
Well, the rule doesn't say you can't amend it. The rule doesn't say under 1.140, it doesn't say you cannot amend it.
It also doesn't say you can't either.
It doesn't say you can, that's correct. And it does say that there's a waiver if you don't raise the argument. We're relying on the Sepro case and on the Snyder versus Metcalf. And in Snyder versus Metcalf, the issue of personal jurisdiction was not raised until more than 2 years after the initial filing. And that's a fourth DCA case. And the trial judge was reversed for finding a waiver of the defense for lack of personal jurisdiction, even though it wasn't raised until over 2 years after the filing. And the court's reason that this was because the defendant took no steps in the proceedings that would amount to submission to the court's jurisdiction, and therefore they did not lead to the waiver of the right to challenge that jurisdiction.
But in that case, was the issue of personal jurisdiction injected before or after the hearing?
I think the motion was filed the day of the hearing with respect to that. But Snyder and the Sepro case both indicate that it's prior to the ruling. And the plaintiffs had a full opportunity to brief the issue, did brief the issue, and the judge waited 30 days in order to do that. Remember, we're talking about the court's exercise of jurisdiction over somebody who has no minimum contacts or no alleged minimum contacts with the state of Florida, who is living in Iowa or living in Texas.
All of which wasn't raised until after the hearing.
All of that was not raised until after the hearing. That's correct. That's correct. So,
Counsel, in line with this argument, do you agree, disagree with the second district's summary of cases like Sapero in their review of 1.140, when they say a review of these opinions that are cited in them, or that cite to them, shows that they do not state a basis or amendment or hearing exception that is all grounded in the text of Rule 1.140? That is unsurprising, as we've shown, and in the before hearing exception to consolidation and waiver of Rule 1.140 G and H finds no support in the text of the rules. The most of these decisions serve as a reasoning is, and this is their summary that I'm asking you to comment on if you agree or disagree. Number one, that not allowing an exception to such circumstances would be hyper-technical. And two, that the purpose of 1.140 G and H is to discourage dilatory tactics, a concern that is not present when the party moves before hearing. Would you agree or disagree that that's a proper summary of all the cases that go contrary to the first and the second statement of 1.140?
I mean, that is the summary of what the court said with respect to that. But I would caution the court with respect to personal jurisdiction, that somebody has a fundamental constitutional right to be free of being hailed into a court in a foreign jurisdiction when they've done nothing wrong, they've done nothing to subject themselves to jurisdiction of that court. And so therefore, I believe that the Sepro and the Snyder decisions, at least with respect to personal jurisdiction, are more in line with constitutional fundamental due process. And remember, Judge Shanko was faced with, if you look at the Slider case, where it specifically said that the judge found that there was a waiver of jurisdiction and then was reversed by the court because they said that prior to a ruling on the matter, you can raise it. Now, that's what we're relying upon. The rule doesn't say you cannot amend. It doesn't say you can't either. I can see that. But what's the harm as long as both sides have had an opportunity to argue that issue? I can see I should have raised it earlier, made a mistake. That's what happened. And I saw the issue after the fact, and I did my best in order to advocate for my clients who shouldn't be hailed into court. But Judge Shenko shouldn't be reversed. He did the right thing because there was no 6th District Court of Appeal decision on this. And he decided and used his discretion not to exercise jurisdiction over people where it hasn't properly been alleged. Remember, alleging jurisdiction is the plaintiff's responsibility. Query, could the court on its own say, counsel, where have you alleged jurisdiction? At the hearing, where have you alleged personal jurisdiction?
But that didn't happen, did it?
It didn't happen.
The personal jurisdiction issue wasn't injected until after the hearing.
That's correct. But they had a full, fair opportunity to brief the issue, and the judge indicated in his order that he considered it, and he made his order. So, that's the best I can do. With respect to the invitation, I'll call it, in the briefs, where the appellants in their reply brief state that the appellees Waddell and Jacobs adopt the appellant's argument, and therefore they're asking, they concede error. I just want to make it clear, we're not conceding, any error with respect to that.
None of the 5 times that they mentioned that you did that, right?
Pardon?
They said that like 5 times and we were saying.
They did say it 5 times. They did say it 5 times, and I couldn't contain myself. I had to break up. So I'm sorry about that, but the trial court did not go outside the 4 corners of the complaint with respect to trying to see if the case could be dismissed. They failed to plead the necessary elements that warrant a constructive trust, which is right apparent from the second amended complaint, and that the cases that they rely upon do not support their position, but actually support affirmance. In fact, the appellants didn't plead lack of an adequate remedy at law. Whenever you're seeking an equitable remedy, you have to plead and show that you lack an adequate remedy at law.
But what's your position with regard to the plaintiff's opportunity to elect a remedy with that argument? So if I follow your argument, it means in every opportunity where they have a cause of action where there may be an equitable remedy, the plaintiff would be foreclosed because they have an adequate remedy in law. If you and I enter into a contract and I breach that contract, under your theory, I wouldn't be able to proceed with the equitable remedy of unjust enrichment. I'd be limited to a document, a contract. And my only cause of action would be a breach of contract. I never could avail myself to an equitable remedy because I am forced to elect at the pleading stage from kickoff what it is that I want to proceed with.
Yeah, and I believe that I addressed that. Yeah, I'll cite to this 6th District Court of Appeals decision in Monaco versus Morgan's Mill, where the defendant faced a claim seeking constructive trust as a remedy and moved to dismiss, arguing that the operative document provided an adequate remedy of law, thereby defeating the claim for equitable relief.
But that's actually different than where we are here. Because there you had a physical document that provided an adequate remedy of law. And the 6th DCA said, well, because you've got one, you can't avail yourself to the equitable remedy. How is that factually applicable to where we are?
Because they alleged the same operative facts against Nick Slinger for tortious interference with an expectancy. All of these transfers, all of these things, they claim that their inheritance is going to be reduced because of his bad behavior in doing it. And therefore, they have a remedy against Nick Slinger with respect to that. And so, if they can prove that, then they will be able to prevail against Mr. Slinger. So they have an adequate remedy of law. It's right on the face of their complaint. They pled it. They didn't plead an actual claim against these defendants. They didn't say they did anything wrong. They just said constructive trust without alleging unjust enrichment or anything else. So that's how I would distinguish that. There is an adequate remedy of law right on the face of the complaint.
Less than a minute if you would.
I'm sorry?
You have less than a minute if you want to wrap up each of their arguments.
Finally, the court didn't abuse its discretion in not allowing the pleadings to be amended to add these parties. Given the causes of action, given the other things that we've raised with respect to this, the judge is within its discretion 3 years into the case to decide to deny somebody leave to add additional parties to the complaint, especially when they're peripheral people. They're nominal people. They aren't people that alleged that anything needed to be done against them. It's outside the main course of the case, and it was within the judge's discretion. I ask that you affirm the trial judge.
Thank you. Robert Field.
Thank you. I'm going to run through just a couple of points briefly. One, there seems to be confusion between what the role of a defendant is and then what the role of a nominal defendant is. The appellants sought to bring in the appellees as nominal defendants. They're necessary. They have trust property. Again, the definition and role of a nominal defendant is someone who hasn't done anything wrong. They bear no responsibility. They need to be brought into the action so the court has some level of control over them. There doesn't need to be a cause of action against them. The appellants properly, sufficiently, and adequately alleged the 3 causes of action that give rise to a constructive trust, and then sought appropriately to bring in those folks who had improperly received trust distributions. Related to trust distributions, paragraphs 104, 105, and 106 related to Meg and Nicole address the Florida property that was sold by Meg in his capacity as attorney-in-fact, not put into the trust as directed, but rather put into his NXT account and then distributed to 3 of them or for their benefit. So the complaint actually does have adequate allegations of improper trust distributions to people who were not supposed to receive them. You brought up Wadlington. Really, the split is Wadlington, and then I think it's the state of Heister, and then Collinson, I think, are the seminal cases in the Supremes, the first, and then the second dealing with constructive trust of remedy only. We would encourage this court to accept that it's a constructive, that it is a remedy only, not a cause of action, in which case we don't have to allege unjust enrichment. Judge Crane, if you address the adequate remedy of law, we don't have to elect, the state of Florida says, until the final judgment. It's improper to rest on that for purposes of supporting a motion to dismiss the complaint. And then finally, related to personal jurisdiction, the trial court never addressed the proper statute. We have a specific statute that relates to trust disputes, and the trial court never addressed it. Judge Startle, I think you addressed this particular issue when going through the Venetian salami analysis in travelers' insurance facilities. That alone related to personal jurisdiction warrants reversal because the trial court wasn't seen to have gone through the proper steps, and the trial court is supposed to go through the proper steps before it assesses personal jurisdiction. We would request that you reverse the challenge order in its entirety, both the dismissal component and the failure to add parties, which we addressed in issue 5 of both our initial reply brief, and we stand on those arguments. Thank you very much.
Thank you very much for the arguments, and we will get you our decision. Court is adjourned for the day.